Putnam County Humane Society vs. Marjorie Dusso, DBA, Oakwood Kennels, Putnam County, Florida. Year case filed, 1998. Jurisdiction level, Florida. Case file number 98-217-SC. Drafting attorney, Gregory and Mulham, PA, Tampa. This case involved a woman named Marjorie Dusso, who is an operator of Oakwood Kennels, which resides in Fruitland, Putnam County. On August 30th, 1997, the Putnam County Humane Society seizes a total of 41 dogs from the respondent, Marjorie Dusso, at her kennel in Putnam County. Putnam County Humane Society is a non-profit corporation that helps to prevent all animal cruelty under the state of Florida law. After the dogs were seized from Marjorie's kennel, she was arrested and charged with multiple violations. This then started an investigation on Marjorie for not properly caring, mistreating, and neglecting the 41 dogs. According to the documents, these animals were living in a very poor environment. Some of the evidence that was witnessed at the scene when the dogs were seized were unsanitary environment conditions, the dogs were infested with fleas, inadequate amounts of food and water, and some of the dogs had severe skin infections that could be possibly contagious to other pets and humans. Marjorie also had no proof of all 41 dogs of having rabies vaccinations with certificates. On April 2nd, 1998, a petition was filed by Putnam County Humane Society. This petition was filed under the Florida statute, section 828.073, which states that an animal can be removed from a present custody due to the neglect or mistreatment of an animal by any law enforcement officer or animal control officer. Under this petition, Marjorie Dusso was prohibited from breeding, owning, or possessing any other dogs besides only animals that she personally owns. This petition also reserves the costs for Putnam County Humane Society for the care and custody of the 41 dogs. In the petition, Marjorie filed a motion for suppression of evidence in the case and is granted by the judge. After the motion was filed, this became a risk for the dogs because there was a chance that the dogs would be allowed to return to Marjorie's possession. In the petition, if the court decides that the 41 dogs can return to her care, it states that the court should set certain guidelines to make sure the dogs are properly cared for and that she pay the cost of care the dogs received by the Putnam County Humane Society. The next step of the case, the petitioner requests that a court date be set on the custody in favor of Putnam County Humane Society. At the final court date, Putnam County courts rule in favor of Putnam County Humane Society and gives them full custody of the remaining dogs that survived and were not euthanized due to poor health conditions. The court did allow Marjorie to keep custody of one of the dogs that she personally owned, named Love, but Putnam County has the right to check on Love once a month to make sure that she is being properly cared for. Lastly, the court ruled that Marjorie is no longer allowed to breed, own, or possess any other animals besides animals that are personally owned by Marjorie. For my synopsis of this case, I feel that it was handled appropriately by the courts, but I do feel that in the state of Florida, it should be a law that both commercial and hobby breeders be licensed for the safety and health of all animals. Commercial breeders are large companies that breed and sell animals, and hobby breeders are breeders that breed animals from their private homes or kennels that are attached to their private residence. Commercial breeders are regulated by the Federal Welfare Act and the Department of Agriculture. Hobby breeders are under no regulations. The Florida Welfare Act became a law in 1966 and is the only law in the United States that controls the treatment of animals, whether it be for research, teaching purposes, testing, transporting, or by breeders. The Department of Agriculture helps Florida's agriculture, environment, consumers, and makes sure that the food we eat is safe. Some ways they help are by ensuring Florida livestock is protected, bees and plants are free from pests and diseases. The difference between a commercial breeder and a hobby breeder is that commercial breeders are required to be licensed in the state of Florida, whereas hobby breeders do not. Commercial breeders also must undergo inspections of their facilities to make sure that animals have what they need on the premises to be properly cared for, such as food, water, ventilation of the building, enclosures such as runs or cages for the animals, shelter, and cleanliness of the facility. Hobby breeders do not need to have any inspections unless there is a complaint filed by someone that thinks that the animals are not properly taken care of and that they are not in good health. There is no limit on how many litters can be bred by commercial breeders, but hobby breeders average about 2 litters a year. In this situation, Marjorie was more of a hobby breeder and not a commercial breeder, and was the reason she was arrested for violations and not having a license to breed in the state of Florida. In this case, it did not specify the violations that Marjorie received, so after doing research, I learned that under Florida statute 828.12, animal cruelty in the state of Florida can lead to a first-degree misdemeanor. There are multiple penalties to being charged with animal cruelty, including serving a sentence of up to a year in jail and a fine of $5,000. If there are other factors in the case that make it an aggravated animal cruelty charge, the sentence is increased to 5 years in prison and a fine of $10,000. I had a total of 6 citations for this case, and they are as follows.